ಹಾಗೂ KSBC ಇವರು ನಡೆಸಿಕೊಡುತ್ತಿರುವ ಬೆಳಕು ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ತಮಗೆಲ್ಲರಿಗೂ ಹೃತ್ಪೂರ್ವಕವಾದಂತಹ ಸ್ವಾಗತ. Today's lecture is dedicated to Sri Dayanand S. Nayak, Senior Advocate from Karnataka High Court. Sri Dayanand Nayak was born on 4th of January 1931 and he had his schooling in various parts of Karnataka, including Hindu High School Karwar and Bessel Mission Convent School Dharwad. He was awarded the Ravadur Chandravarkar Award for the best student. He completed law from the Government Law College, Bombay in 1957. He was a student of late Sri H.M. Shirvai, former Advocate General of Maharashtra. Mr. Nayak enrolled with the Bar Council of Mysore on 7th of February 1958 and started his practice at Karwar on 10th of February 1958. Later on, from 1961 to 1965, he worked along with late Justice Sri G.N. Sabahi. He was appointed as District Government Pleader and Public Prosecutor for North Karnataka District in 1966, which post he continued to hold till 1971. As a public prosecutor, he had the unique distinction of conducting all the sessions cases, and the pendency was nil by the end of his tenure. He was the chairman of the organizing committee on behalf of the Karwar Bar Association, which organized the 3rd Karnataka State Lawyers Conference in December 1983 at Karwar. The function was presided by the then Chief Justice of India, Sri Y.V. Chandrachud, and the then Chief Justice of Karnataka, Sri V.S. Malimat. He was actively practiced before the Karnataka High Court, Bangalore from 1994 to 2010, and later before the circuit benches at Dharwad and Kalaburgi. He also appeared before the Panaji bench of the Bombay High Court. He put in nearly 55 years of practice. His junior colleagues from his office, Justice P.D. Wangankar, was the judge of the Karnataka High Court from October 2013 to April 2016. He has mentored several junior colleagues and associates. Sri Dayanand Nayak passed away on 7/10/2016, and his son, Mr. Murthy Nayak, he is a designated senior advocate practicing before the Karnataka High Court, both on civil and criminal side. Today, we have in our midst the living legend of the Karnataka High Court, who has spread his knowledge and the light of his envision throughout the country. Bhishma Pitamaha of the Karnataka High Court, Sri B.V.Acharya, Senior Advocate and former Advocate General. Without much ado, I request Sri B.V.Acharya to take over and give the lecture on today's topic. So over to you, sir.
Good evening, everybody. I feel privileged to have been invited by the Karnataka State Bar Council Academy to deliver this lecture. I am extremely happy because this lecture is in memory of my dear friend, late Sri D.S. Nayak, whom I have been knowing for a very long time. Now about Sri D.S. Nayak, Mr. Basavaraj has already told us about his achievements. Though he is 2 years younger to me, he was enrolled in 58, whereas I was enrolled as an advocate in Mysore High Court in 1957, 1 year earlier. And it is a coincidence that during the period he was the public prosecutor and government pleader of Karwar, I was holding the post of additional PP from 61 to 64 and as district government pleader from 1967 to 1971. It is in that capacity that I had come in close contact with him, and I also attended the law conference in Karwar, where Mr. D.S. Nayak, in a lighter vein, said that he is jealous of Mr. Acharya because he is the government leader in Bangalore, where large extent of land has been acquired for Mangalore port, whereas in Karwar, there is no land acquisition case at all. He is a very friendly person, and I actually met him. Mr. Murthy took me to his house, and one day we had a very long time talk about our past. According to me, Mr. D.S. Naik has occupied all the high positions which one could occupy in the state, in the district. Public prosecutor, government pleader, president of the bar, so and so. And he was also the commandant of the home guards. So it gives me pleasure to talk, give a lecture in his memory. I thank the Academy for giving me this opportunity. I also thank Mr. Murthy Naik for all his cooperation in this behalf. Now, coming to the topic of the day, role of judiciary in protecting personal liberty. Now, personal liberty is a fundamental right. It is a liberty of this liberty of an individual is precious and is one of the most cherished fundamental rights enshrined in the Constitution. The reference made to the Articles 21, 19(1), 21, and 22 of the Constitution, which deal with these rights. Now, Article 21 says no person shall be deprived of his life or personal liberty except according to law, according to procedure established by law. And the later rulings have laid down that the law envisages it is one which must be just, fair, and reasonable. The effect of this judgment and the procedure, though word used is established, procedure established by law, it actually means due process of law. That is the position. Now, it is the duty of all the courts in this country to ensure protection of this fundamental right. In fact, it is considered that Supreme Court is the guardian of the fundamental right. The Supreme Court has recently held, disagreeing with A.K. Gopalan, that the rights granted by each one of these articles should not be considered as separate rights. There may be a case of overlapping, and all the articles in Part 3 should be together with as one conjoined fundamental rights. Now, what is the remedy where this liberty is curtailed? If the same is done by a private individual, normal criminal law will take course. That is, a person is wrongfully restrained or he is wrongfully confined. These are all penal provisions and you can approach a court of law. But we are concerned with cases of this liberty being taken away by the state and its agencies, and deprivation of this liberty, whether by state or private individual. One important remedy that is available to a citizen is writ of habeas corpus before the High Court. The High Court will see that the person who is wrongfully confined is released. In fact, for a writ of habeas corpus, I am told in England the procedure is if a habeas corpus petition is filed, the court will suspend all other work and give priority to this case because it involves the liberty of a citizen. Therefore, that is the priority. In our country also, writ of habeas corpus is given priority, and we know many cases where the high courts have granted adequate relief wherever there is illegal detention, whether by the police or a private individual or any other agency of the state. Then there is another provision, procedure by which the liberty is curtailed or done away with by the state. That is the provisions for preventive detention, which is common in our country also. Now, regarding this preventive detention by the state, Article 22 deals with the subject. It puts so many restrictions on having preventive detention law. First, it says it shall not be more than 3 months, and beyond 3 months, it must be confirmed by an advisory board consisting of sitting or retired high court judges. Then there is a right of making representation for the authorities to revoke the detention. Now, if such a representation is not considered and disposed of immediately, that itself is a good ground to quash the detention order. Similarly, if there is any procedural lapse in the matter of preventive detention, then again the court will be very strict and the detention order will be quashed. These are the relevant provisions relating to preventive detention. Now, I come to the most important aspect. That is, the liberty is taken away or violated by none other than the police or other investigating agencies. Now, under what circumstances they could arrest and what is the procedure thereafter, I will be dealing with it before I go further. First and the foremost point I want to say is, what is the relief which you can obtain to prevent arrest? Because arrest is a very serious matter, and a person who is once arrested will suffer huge social stigma. It will be a is held to be a fundamental right, and the Supreme Court has, quoting from Bhagavad Gita, has said, "Sambhavitasya cha kirti marana dapi kita gati." That is, for a man with honor, ill fame is worse than death. And the Supreme Court has also quoted with reference to Article 21, Joseph Addison, who says, "Better to die 10,000 times than wound the honor." One will not be prepared to lose the honor. If dignity or honor vanishes, what remains is life. This is the significance of Article 21. Therefore, anybody, if arrested, will suffer all this humiliation. So, what is the provision to prevent a wrongful arrest? Before 1973 Code of Criminal Procedure, there was no provision for anticipatory bail or for a direction that in case of arrest, he will be released immediately on bail without being in the custody of the police or in jail. And there was difference of opinion between various high courts whether such a power can be inferred or not. It is then that in the year 1969, the Law Commission of India proposed in its 41st report that there is need for a clause in the law which will authorize the courts to grant this relief. Now, this section 438 of the Criminal Procedure Code, which is not law after the 1st of July, and now we have the new provision, which is anyway.
Murthy?
Yes.
New section.
I think corresponding.
482, sir.
Anyway, 438 was inserted for the first time in the 1973 Act based on the recommendation of the Law Commission. The Law Commission in this report of 1969 said like this, which is quoted by the Supreme Court in the Constitution bench. I'll just go necessity of granting anticipatory bail arises mainly because sometimes influential persons try to implicate their rivals in false cases for the purpose of dissuading them or for other purposes, getting them detained in jail for some days. In recent times, now this is very important, with the accentuation of political rivalry, this tendency is showing signs of steady increase. This is what they have said in 1969. Today you will visualize how much increase it has. Influential persons and political rivals misusing the provision for arrest to it is for that reason. Therefore, they say, apart from false cases where there are reasonable grounds for holding that a person accused of an offense is not likely to abscond or otherwise misuse his liberty while on bail, there seems to be no justification to require him to first submit to custody, remain in prison for some days, and then apply for bail. We recommend acceptance of this suggestion. We are further of the view that this special power should be only to the High Court and the Sessions Court. Magistrates are not given this power. No. Pursuant to this, this recommendation was further considered, and ultimately Section 438 is there in the statute book. Now, on this question of anticipatory bail, there are two very important judgments of the Supreme Court all through. The first one is the judgment in Gurubaksh Singh Siddha. To my knowledge, this is the only Constitution bench judgment dealing with the position of Article 438, 1980 Supreme Court Reporter 383. And the other judgment is Siddhalinga Maitre, which is popularly known as Maitre case, that is reported in 2011, 1 SCC, page 694. These are the two judgments. This judgment, second judgment, Maitre, is delivered by Justice, author of the judgment is Justice Dalvir Bhandari, who is now the
IC.
Judge of the International Court of Justice. It is a very illuminating judgment. This Constitution judgment is authored by Justice Y.B. Chandrachud, one of the most illuminating and historic judgment. In that, the Justice Chandrachud says, but the crimes, the criminals and even complainants can occasionally possess extraordinary features. When even flow of life becomes turbid, police can be called upon to inquire into charges arising out of political antagonism. The powerful process of criminal law can then be perverted for achieving extraneous ends. Attendant upon such investigation, when the police are not free agents within their sphere of duty. That is the position today. They are not free agents in many cases. A great amount of inconvenience, harassment, and humiliation that can even take the form of parading respectable persons in handcuffs, apparently on the way to court of justice. The foul deed is done when the adversary is exposed to social ridicule, oblique, no manner when and whether a conviction is secured or is not possible at all. It is in order to meet such situations, though not limited to them, the power to grant anticipatory bail was introduced into the code in 1973. This is the reason, as has been stated by the learned judge. Now, the one question that was always arising is whether there is a power to grant interim order in a bail. Now, this Constitution Bench judgment itself has said that it is not only permissible to grant interim order in the normal course if the court finds that if the application is not frivolous or vexatious and a matter has to be considered hearing both sides, then interim order should be granted. And then immediately public prosecutor should be notified, both should be heard, and ultimate decision taken. If that is not done, and if in anticipatory bail at the first instance itself, you adjourn it for 1 or 2 weeks, and it goes on for months together, the object will be defeated because by then he will be arrested. And once he is arrested, the whole thing becomes infructuous. Unlike in some other states, in our High Court state, the courts are reluctant to grant interim orders, and they are very rarely granted. Now, in this celebrated judgment of the Constitution Bench, I will refer to one passage is very important at page 419. There was some discussion before us on certain minor modalities requiring passing of bail order under 438. Can an order be passed under that section without notice to public prosecutor? It can be. But notice should be issued to public prosecutor or government advocate forthwith. And question of bail should be re-examined in the light of respective contentions of parties. Once you grant interim order, immediately give notice. Then after hearing, till then, the ad interim order too must conform to the requirement of the section and suitable conditions should be granted. And then another, should the operation of the order passed be limited to a point of time? Not necessarily. They said it never. But in practice, now this view is considered in the Maitreya's case in the year 2011, 1 SCC 694. I'll read two sentences. Para 94. The proper course of action to be, after evaluating the evidence and accusation available on record, if the court is inclined to grant anticipatory bail and an interim bail be granted and notice be issued to the public prosecutor. After hearing PP, court may either reject or confirm the final order of bail. This is the position reiterated, and then it says the court would certainly be entitled to impose conditions. Public prosecutor or complainant would be at liberty to move the court for cancellation or modification. Bail granted by the court should ordinarily be continued till the trial of the case. And this court said, in the meantime, from 80 to 2011, almost every bail order was for a short period, asking him to apply for regular bail and all that. Now, by this judgment, they say all the judgments, even of the Supreme Court, making such provision for a limited period is bad because it ignores the law laid down by the Constitution bench, and therefore they are for incurium. With that, the position has been clarified. So as on today, interim order can be granted and the bail need not be limited to a period. Once anticipatory bail granted, unless cancelled, it will remain up to the end of the proceedings. These are the important points made out. Then the Constitution judgment was against the judgment of the Punjab and Haryana full bench. And in that they said, full bench said, this it is an extraordinary remedy, should be granted in the rarest of rare cases, and to grant this special case must be made out by the accused. And it should be only for a limited period. All these statements of law made by the full bench was reversed by the Constitution bench. But even now, some people think on these lines that it is to be only for a limited period. It must be in rarest of rare cases and all. In fact, in Mehta's case, they say there is not much of a difference between bail and anticipatory bail, and in appropriate cases, it must be granted. Now, grant of this, if you don't grant an interim order, you are virtually saying you have gone, which is not a happy thing at all. And the object of this anticipatory bail has now become more relevant because of the present situation in our country. The center and the states are ruled by different political parties. The criticism that the ruling party misuses its power because the investigating agency is always under them, whether it be center or states, are misusing their power against political opponents. The result is the center agencies arrest the state ministers, state bureaucrats. One chief justice, of course, he resigned before arrest. One is continuing in prison and ruling from there as the chief justice. This is a very anomalous situation. Similarly, state governments, particularly in state some places, there is no exception. The local police file cases against the officials of the ED or the central government officials. If this sort of things happen, it is a very unpleasant thing. Now, because of this development, the responsibility of the courts have increased in the matter of grant of anticipatory bail or bail, because there should not be misuse of this power while it is necessary that rule of law should prevail and accused who are really guilty must be dealt with in accordance with law. Now, I'm sorry, did I make a mistake? I said the arrest of chief ministers, not chief justice, chief ministers
Yes.
in Jharkhand and Delhi. That is the situation. I'm sorry if I made a mistake.
The days are not too far sometimes. Political vendetta.
Now you see, I deal with the question of power of police to arrest. Now, section 41 of the Criminal Procedure Code and 41A, B and D deal with the right of arrest. The present section under the BNSS is section 35 to 38. Now the police must have the power to arrest under certain circumstances. Power is necessary, but it should not be misused. Therefore, these provisions, section 41 itself, places a restriction. The condition precedent for arrest must be satisfied. And section 41A was introduced for prevention of arrest, where the offense alleged is punishable with less than 7 years. Then you should not arrest, but issue a notice and not be arrested. His statement should be recorded. And also 41B and D also place certain restrictions on misuse of the. In addition to these statutory provisions, the Supreme Court had to issue specific guidelines because of the large-scale misuse of this power of arrest. And the case is one very important case of the Supreme Court in this behalf is the case of Arnesh Kumar. That is Arnesh Kumar versus State of Bihar. This is a case of 2014 judgment of Justice Chandramouli Prasad. I'll read only few lines. Arrest being humiliation, curtails freedom and scars forever. Lawmakers know it is so. So also the police. There is battle between lawmakers and police. And it seems that police have not learnt a lesson implicit and embodied in CRPC. It has not come out of its colonial image. Despite 6 decades of independence, it is largely considered as a tool of harassment operation, surely not considered a friend of the public. Then it says, as the arrest curtails freedom, brings humiliation and casts scar forever, we feel differently. We believe that no arrest should be made only because the offense is non-bailable and cognizable and therefore lawful for the police to do so. The existence of power to arrest is one thing. The justification For excise, it is quite another. The existence of power, apart from power to arrest, police officers must be able to justify reasons for arrest. No arrest can be made in a routine manner on a mere allegation of commission of offense. It would be prudent and wise for police officer that no arrest is made without reasonable satisfaction reached after some investigation as to the genuineness of the. Then they refer to section 41 and 41A, B, C, which places restrictions. And they lament that in spite of these directions and provisions of law, misuse is continuing. And therefore, as on today also, though this law is laid down by the Supreme Court and guidelines are issued, and those the cases of police excesses and unwarranted arrests are not uncommon. Certainly no. And then, even if there is an arrest, one very main restriction is placed. The police, even if they arrest, the duration can't go beyond 24 hours. The power of police to detain in his custody is only for 24 hours. Within 24 hours, he must be produced before a magistrate. This is not only the provision in law, but a constitutional guarantee. Article 22 itself says the accused must be produced within 24 hours. And then further detention could be only by the order of the court. That is sub-article 2 of Article 22. And in this Arnesh case, the Supreme Court lamented that many magistrates, the moment police seek a remand, immediately they give their custody or judicial custody in a routine manner, in a mechanical manner. They say no. The magistrates have a great responsibility. Magistrates and nowadays even special judges who have power of remand in special enactment like Prevention Corruption Act and other provisions. The Supreme Court has said that the magistrates must first of all find out whether the arrest was justified and legal. If the arrest itself was not justified or legal, it should not remand the accused to custody. And the magistrate should not act merely on the ipse dixit of the police officer. He must ascertain all the facts, and if only it is necessary to remand, then only it must be done. And the Supreme Court in this very judgment of Arnesh Kumar further pointed out that in case the magistrates do not perform their duties properly and order remand in a casual manner, they should be liable even for disciplinary proceedings. This is what the Supreme Court has said. This is the it says, I read that sentence, authorizing detention without recording reasons as aforesaid by the judicial magistrate concerned shall be liable for departmental action by the appropriate High Court. Thus, the function of the magistrate, which is again the safeguard against illegal curtailment of the liberty of a person. Now, if the accused is arrested and the magistrate or the judge also thinks it proper to remand him to custody, police custody could be only 15 days and not more than that. Thereafter, it has to be only judicial custody. If that stage is reached, the next stage is what can you do to get back the liberty which has been taken away. Now, section 437 CRPC, now it is 480 of BNSS, power of the magistrate to grant bail. Now the magistrate has power to grant bail in all offences except one where the punishment is death or imprisonment for life. If it is death or imprisonment for life, then the magistrate has no power. In all other cases, he has power. But even in a case where the offence is punishable with the death or imprisonment for life also, the magistrate has power to grant bail in respect of 4 categories. That is, one who is below 16 years, a woman, this is very important. This is sometimes totally forgotten. Woman stands on a different category and magistrate is given the power even if it is a case of murder and punishable with death or imprisonment. A woman can be granted bail. And High Courts and Supreme Courts have also said she stands on a different category. Then anyone who is sick or infirm, barring these others, magistrate has power to grant bail, and it is necessary that it should be granted bail subject to conditions. Then 439 CRPC, now it is 483 of BNSS, the High Court and the Sessions judges are given power to grant bail. Now, in the matter of grant of bail, certain fundamental principles are sometimes not taken note of by the concerned judges. One important point throughout made out is detention pending trial cannot be by way of punishment. You can't deny bail as a measure of punishment. Punishment is only after trial and after conviction by a court. Second is, a judge must always remember that there is a presumption of innocence in favor of an accused till he is found guilty and convicted. These are some of the important considerations. In fact, during trial, the requirement of detention of an accused is to see that he is always available for the court to try him. He should not abscond. And second is, he should not tamper with the prosecution evidence. And in fact, in one Supreme Court case, it has said, as early as in 1980, if a prima facie case is made out simply because there is a prima facie case, they can't say bail cannot be granted. It is only in a case where there is prima facie some material, therefore there is a case for trial. But till the trial is over, he must be granted bail, imposing suitable condition that he will be available for trial and he will not tamper with evidence. These are all matters of discretion. Generally, barring exceptional cases of murder and rape and other heinous offences, the general proposition is that the courts must lean in favor of liberty and be liberal in the grant of bail. And this has been the opposition throughout. And one of the practical considerations is Supreme Court says in the entire country, 70% of the persons in prison are under trials who have been not granted bail. And there is a lot of congestion in the prisons, always overcrowded. And this is the position. And no cases are disposed of immediately. There is hardly a criminal case which is over even 2 or 3 years. It takes a long time. Therefore, now I am very happy that the right of speedy trial is recognized as a fundamental right. And the certain laws like the EAPA and this PMLA, these are the two enactments where getting bail is very difficult because the legislature says to grant bail, you must record that he is not guilty. How is it possible? This is totally contrary to the fundamental principles of jurisprudence. And Section 45 of the PMLA, when matter came up before Supreme Court, a bench presided over by Chief Justice Rohit Nariman struck down that provision. They again reintroduced it with some modifications, but in substance, retaining the same restrictions which make it impossible. And unfortunately for us, a later bench of the Supreme Court straightaway upheld all the provisions which are contrary to fundamental principles, putting the burden on the accused to prove innocence if he is to get bail, ignoring the presumption of innocence and burden of proof, everything. Now, these are the provisions. Unfortunately, PMLA now review is being considered very shortly. We hope the parties will get some relief. But till then, the Supreme Court tried to dilute these provisions. Now, very happily, since the last few days, more than one judgment they said, right of speedy trial being a fundamental right. Wherever there is violation and you are not able to finish off the case immediately, accused must be released, notwithstanding stringent provisions under the PMLA. And yesterday, bench presided over by Justice Oka applied it even for UAPA.
Yes.
Even UAPA, if trial court is not possible.
Yesterday, sir.
And these investigating agencies, in their anxiety to show that they have built up a very strong case, in the case of Mr. Kejriwal himself, containing 1 lakh pages and 493 witnesses. Now, by saying all this, they themselves, virtually, they incurred self-goal. The court said, if these are the number of witnesses, these documents, when are you having the trial? How long will the trial take place? Can we keep them in prison for 4 or 5 years till the trial goes on? There are now many cases which we know where even 4 or 5 years trial is not completed. Therefore, having regard to the state of affairs about the speed with which trial takes place, it is absolutely necessary that the courts should be liberal in the matter of grant of bail. And of course, some time back, the investigating agencies started putting for new ground is a flight risk.
Flight
And
risk.
then saying that in economic offences, the investigation is very difficult and therefore the accused has to be in custody. It is on those grounds the bail is rejected. And that is how even a person like Chidambaram could not get anticipatory bail and bail for considerable length of time. This is a very unsatisfactory state of affairs. For the first time in Chidambaram's case, the Supreme Court somehow felt that in respect of economic offences, bail should not be granted. And wherever there is flight risk, bail should not be granted. They went on saying this. And Mr. Chidambaram, I am not saying as a former minister, but as a senior counsel practicing before the Supreme Court, he got anticipatory bail, interim bail from a session judge. And he heard him finally and reserved judgment. And after 6 months, just before retirement, he rejected the anticipatory bail application. And Mr. Chidambaram was unable to get his SLP considered by the Supreme Court for 3 days. And in the meantime, the CBI jumped over his compound wall and arrested him and rendered it infructuous. You see, these things show us how important bail and anticipatory bail is and the responsibility of the judiciary. If judiciary, after considering the case, rejects its order, it is not even in considered means what. That is the unfortunate situation. Therefore, the courts must give priority to these cases of anticipatory bail and bail because it is a matter of personal liberty. And it is a matter of great satisfaction for us that recently the situation is good, the trend is good. The Supreme Court is expressly opining that the court should be liberal in the matter of grant of bail. Now, the Chief Justice of India openly in so many public meetings said that the district and session judges and magistrates are playing safe by refusing. Though he has sent this message to the district judiciary and magistrates, in effect, I feel it is a message to the High Court and his brother judges also, because they must also take a clue from this message which has been given by the Chief Justice. And it's a matter of satisfaction that many senior judges of the Supreme Court, including Justice Gawai and Justice Oka, who have been dealing with these matters, have come out openly and have said that the provision for grant of bail should be liberally construed. I hope the message sent by the magistracy, the Supreme Court and the Chief Justice of India will percolate down up to the magistrates, and they will not fail in their duties to grant liberty, the order in favor of personal liberty of a citizen. Oh. I think I'll take about 10-15 minutes and another part which plays is to prevent arrest or to protect the liberty of a citizen is section 482 of the criminal procedure code, inherent power, quashing the proceedings in which you grant stay, either quash, stay, or grant not to arrest the person. Now the Supreme Court unnecessarily puts fetters on this power of the High Court. In the case of America infrastructure, 2 or 3 years back, they said by invoking inherent power, you can't order not to arrest, not to take coercive action. Such orders should not be passed. Now, such orders have prevented thousands of illegal arrests. I have written a detailed article in which I say inherent power is a power inherent in the High Court. It is not a power conferred by anybody, not even the Constitution. 482 doesn't confer any power. It only says it recognizes the inherent power of the court. Justice Rankin clarified it in the Asian surface case. It is an inherent power and you can't curtail it. And according to me, even Supreme Court has no right to curtail that power. And therefore, I feel power under 482 also requires to be exercised properly and liberally so as to now I'll take only 5 more.
Sir, please,
minutes.
continue.
Now,
we are all here.
The Supreme Court has been in the constitutional law evolving some new grounds to strike down the law. In addition to the grounds which are already available, that is any law which is contrary to the constitutional provision. They said no constitutional morality. No, yet another important principle laid down is that even a plenary legislation, the courts have power, constitutional courts have power to strike down even a plenary legislation if the same is found to be manifestly arbitrary. So manifest arbitrariness is a ground for attack. Now my submission is these stringent provisions like section 45 of the PMLA and similar provisions which say bail should not be granted contrary to the fundamental principles of criminal law. Such laws, the constitutional courts must take courage to strike down such laws as unconstitutional because they have the effect of abridging or curtailing the powers, liberty of the citizen. two other rulings of the Supreme Court which we must welcome is, they said in PMLA, ground of arrest must be given in writing. That is one good thing. Secondly, one happy thing is they say degree of satisfaction for arrest also must be higher. And another thing which is to be welcomed is the courts have now recognized that apart from claiming bail, you can challenge the validity of arrest itself. In fact, they held that in the case of Hemant Soren, the arrest itself is illegal without satisfaction. So this way, the Supreme Court has been recently invoking new provisions to save and protect the liberties of the personal liberty of the citizen. Thus, I feel I have sufficiently explained how there is heavy responsibility which rests on shoulders of the judiciary, right from the level of the magistrate, session judge, high court, and the Supreme Court to protect the liberty of citizens. I hope the judiciary will continue to perform its constitutional functions effectively to protect our personal liberties. Now, before concluding, my Independence Day greetings to all our listeners. Thank everybody for your patience.
Sir, that was a magnificent speech. Just to add, I think yesterday the Supreme Court bench, Justice Abhay and Justice A.G. Mais, in the matter of even unlawful activities prevention act 1961, bail is the rule and rejection is the exception. Fortunately, the subject we have chosen is timely in the sense that just yesterday the Supreme Court has declared that even in the UAPA cases, bail shall be the rule comparatively. That's one. And the Karnataka High Court, in the matter of that Bhavani Revanna matter, Justice Krishna Dikshit has said that women are the epicenters of family life, and women by their very nature deserve preferential treatment inter alia in matters relating to bail, regular or anticipatory. Recently, Justice Krishna Dikshit. What I'm saying is I'm proud of Karnataka High Court because they are evolving such revolutionary. This one in 2021 itself, that is the judgment dated 16/3/2021 regarding that PMLA. Even before, I think the Supreme Court, Justice Suraj Govindraj said that the PMLA Act objective satisfaction of the investigating stroke arresting officer about guilt of an offence under the Act is mandatory. The same is required to be reduced in writing prior to arrest to be furnished to the arrestee at the time of arrest. This was in 16th of March 2021 itself. So, sir, and recently Justice Vishwajit Shetty in the matter of that murder of Gauri Lankesh. Yeah, prolonged trial where there is no possibility of seeing the light at the end of the tunnel, then bail has to be granted, and he did grant bail in Gauri Lankesh murder case.
And there COCA provisions are invoked.
Okay, yes,
a very stringent COCA provision has been invoked. Our High Court had, in fact, struck it down, then the Supreme Court later set it aside. In fact, it was just Kunna who struck it down.
One aspect which I would like to say is, as I said, woman stands on a different footing, notwithstanding all that. In an ordinary case of kidnapping, where a lady is plugged in as a conspirator and the High Court grants anticipatory bail, is there any justification for a government to approach the Supreme Court with the SLP? And they have got Advocate General and so many additional Advocate Generals, but they engage the President of the Bar Association, Supreme Court, a senior counsel who generally champions cause for liberty, pressing for SLP being admitted. And I am sorry that the Supreme Court also, after repeatedly saying it is not a case for consideration at all, ordered notice.
Notice.
The governments also have a great responsibility to see that unnecessary appeals are not filed, even where bail is granted.
As a matter of fact, this is a matter where the Alibaba is caught hold of and 40 thieves are roaming. That's what it. Even the court was surprised. I think last week, the speed in which the charge sheet was filed, 3 volumes of charge sheet consisting of more than 2,000 pages were filed in an astronomical speed. Therefore, what I am saying is, in some cases where political angle is evident, this speed in which the investigating officer and the entire police team proceeds is something really alarming compared to other cases involving heinous crimes. And the playing safe, I must say that it's not confined only to the lower courts. It does apply to high court, especially in a matter where there is a tendency of public opinion going against the judges and all. Sometimes they too, fall prey to such emotional attacks, possible emotional attacks.
And in fact, all said and done, our only hope is judiciary. And judiciary must bear the sole responsibility. And
Sir, historically speaking, it was the Supreme Court which failed during the emergency and laid down such a stupid judgment like ADM Jabalpur, which was overruled by his son. Father's judgment for ADM Jabalpur was overruled by his own son in Justice Puttaswamy's case. Now, they were the high courts which upheld the personal liberty across the.
Yes, all over, including Karnataka High
Karnataka
Court. Similar is the position with regard to Chidambaram's case. They, I think the bench consisting of Justice Bhanumati and Bopanna, they accepted the contention of the state that economic offences stand on a different footing and flight risk and all that.
Notwithstanding the transfers left, right, and center, the high courts which safeguarded the liberty in those days, during the emergency, than the Supreme Court,
Yes.
Except the silver line
And
of
one peculiar situation you may find, Mr. Kejriwal's case, ED, I think he has been granted bail by the Supreme Court, but he is still in custody in the
CBI case.
In the CBI case. In fact, the CBI case should have been first predicate offense. When he is in custody of ED, he was arrested, though he was in custody. That's why his lawyer was contending it is an insurance
Arrest.
case. Insurance arrest. In case he is granted bail in the other case, he may not get the freedom.
Case of anticipatory arrest.
How it is possible in one case you are in same set of facts, 2 investigations, 2 charge sheets, and 15 days remand by the police is over, then the ED will step in. Very anomalous situation.
So, Gautam sir, out of thanks.
Yes, please. Hello, what of thanks? Okay. Good evening, all. It's indeed a pleasure and enlightening session on role of judiciary in protecting personal liberty by Honorable Mr. Sri B.V.Acharya, Senior Advocate, 3 times Advocate General, and he has a practice of 67, almost 66 to 67 years. My age is 58 and 59, and his practice is 67 years.
in 5-time advocate.
No,
On
he
behalf
said, Mr. Acharya sir said, all the sitting judges of the Supreme Court were born after my enrollment. This is what he
enrollment. It is I express a sincere gratitude and thanks on behalf of Karnataka State Bar Council and KSBC Law Academy for your timely lecture, and it was a most relevant aspect, and you have enlightened all. See, right from 1953, how these laws were amended, and Supreme Court interpreted the law. Bail is the law, bail is the rule, and jail is the exception concept. In fact, I remember that Menaka Gandhi's case also, wherein her passport was seized and she was not allowed to go out. There also the personal liberty was involved under Article 21. She was permitted to go. Sir, in fact, it's our pleasure and to make it known to the audience that KSBC Law Academy, when it was founded, Sri B.V.Acharya was one of the trustees. And today, after so many years also, he is serving our fraternity without any this thing. And at this age, I'm amazed ನಮ್ಗೆಲ್ಲ ಏನಾಗುತ್ತೋ ಗೊತ್ತಿಲ್ಲ. So taking so much of time and preparing himself and presenting himself in this new technology era. And maybe ಅವ್ರ ಕಾಲದಲ್ಲಿ ಇದ್ದೇ ಇದ್ದಿಲ್ಲ ಈಗ ವೆಬಿನಾರು ಮತ್ತೊಂದು ಮುಗ್ದೊಂದು. Today he is getting prepared himself and he is presenting the lecture online. That itself is commendable. Thank you very much, sir. And I thank one and all the audience, Mr. Basuraj, Mr. Murthy Nayak, and all others who have cooperated and supported this concept. In fact, Mr. Basuraj it is the brainchild of Mr. Basuraj to start this Belaku, start this memory lecture series in memory of reputed advocates whom we have to recall. For judges, there are so many other things. For lawyers, it is necessary we should recall their contributions and then simultaneously give lectures on various topics. Thank you, one and all. Thank you.
Thank you, sir. Thank you.